dismiss history at our peril.
Liberty Nation Radio with Mark Angelides.
And you're back on Liberty Nation Radio with me, Mark Angelides, and Scott Cosenza, Esquire. And we have been discussing civil rights, civil liberties, the Department of Justice, and we're going to round it off with a rather interesting discussion on latest cases through the Supreme Court pertaining to gun rights. Scott, what have you got for me?
Well, I think the most interesting case to be argued, that will be argued before the Supreme Court in this term, is the Hamani case regarding guns, certainly.
U.S. versus Hamani.
U.S. v. Hamani, which is a case that it's going to, basically when you fill out for, all right, this is going to take a moment just to delineate for people who have never purchased a gun in the United States at a federally licensed firearms shop. You have to fill out a form and you have to disclose a number of things and make some certifications. For instance, that you've never been adjudicated mentally incompetent or harm others, that kind of thing. You're not a felon. You're not wanted. Just a number of things. You're of age. And also you're not an unlawful user of basically drugs. Now, the question is whether or not it's legal to require an affirmative answer to that or legal to require that as a function of being able to own a gun. We don't have to answer any questions to observe our fundamental rights in any other capacity. There's no pre-clearance qualification. And the thing that's fascinating to me, one of the many things that's fascinating to me about this case is we have now in a situation in America where any marijuana use, possession, cultivation, you name it, is a federal felony. And a felony is the most serious crime that we can delineate in our system, and yet those events are happening legally under state law all the time, often with state permission and sanction. So you have many thousands, if not millions, of people in America who have, for instance, medical marijuana ID cards or non-medical, permission cards that let them purchase marijuana, and a significant number of those same persons are going and purchasing firearms and saying they're not an unlawful user of marijuana. And it only would take a motivated, I think, president in concert with some governor who are both hostile to gun rights to kind of really light a fire on this claim and really kind of imprison lots of Americans for it. So this case may have impact on that. And I find it a fascinating issue because of it.
What really strikes me, pretty much the first thought that popped into my head and I'm almost certain this will be one of the thrusts of the argument when it is heard by the court, is that there's a difference between an habitual user and somebody who has used, right? And so...
But I believe the statute reads unauthorized or habitual.
Okay.
So I think it can be both. Habitual or regular. It equates unlawful with habitual and or regular use.
And so this is why I guess it's at the Supreme Court, right? Because there's a lot of difference between state laws. And let's say, for example, it's habitual or unlawful use, right?
Mark, I want to just add this. I know we don't have a ton of time, but there's another component that's fascinating, which is you could be a habitual user of marijuana and not use it unlawfully, meaning you could travel to a false...
This is exactly the point I'm making.
Yeah. Yes.
Yeah. You could use it lawfully in one state.
Well, I'm talking about, presumably then your use would still be unlawful under federal law. What I mean is it's not illegal if human travel to the moon was capable now, and we had getting for us, right? Or just international waters. William F. Buckley, the dean of conservatism, posthumous, he famously went to international waters with his sailboat to smoke a joint so he could say that he never broke the laws of the United States in consuming marijuana. Now, of course, there was a conspiracy to consume. He knew it before he left that he was going to be doing it. So we can quibble about that some other time. But so that's a fascinating angle to it, too. I expect that we're going to see some interesting outcomes from this case where we may see people who we may not consider to be sympathetic to marijuana use vote that it is unconstitutional to require this, and then some others who we may think are hostile to gun rights come out a different way. So,
yeah, it actually, I think we might not get a big result out of this one way or the other, because I don't think this is going to be a bright line ruling one way or the other. However, there's going to be some fascinating arguments coming out of here, and I think that am I right in thinking that it was Justice Alito that took this on board?
Well, this is a case out of the circuit, right? And Justice Alito typically handles appeals from the Third Circuit.
Okay.
Appeals. But also sometimes they are subbing in for others, depending. And I haven't checked before we went to air. But let's recall, to be granted for the Supreme Court to hear it, 4 justices have to agree. So Alito or another justice may have granted like a restraint or a temporary stay, but at least 4 justices think this is an issue worth spending our time on. So,
and it absolutely is an issue worth spending. Anything that impacts an individual's constitutional rights is worth spending time on. Scott Cosenza, thanks ever so much for joining us on the show today. Really appreciate it.
Cheers. Thank you, Mark.
And that's all we have time for on this week's edition of Liberty Nation Radio, heard coast to coast on the Radio America Network. I've been your host, Mark Angelides. I'd like to thank our guest today, Scott D. Cosenza, and of course you, the audience, for taking the time to tune in and join us. Please remember, Liberty Nation does not endorse candidates, campaigns, or legislation, and this presentation is no endorsement.
We dismiss history at our peril.
Liberty Nation Radio with Mark Angelides.